Good morning, everyone. Welcome to today's class. Uh, I'm your facilitator for today. As you can see on your slide, uh, we're going to be today's model is business law, registration of business, compliance requirements. My name is Fomi Ohana, and we're going to discuss today's module together. So, what is it? Participants are expected to learn by the time we're done with this class. So, participant by the end of today's module should be able to, sorry, speaking time. Okay. Participants should be able to have a basic understanding of the nature of the legal system in Nigeria. So by the time we are done with today's module, you should have an understanding of what the legal system in Nigeria is like to enable participants understand the legal regime and regulatory agencies regulating businesses, for participants to know the types of business organizations and the steps in the formation and registration of business in Nigeria, they understand the basic nature and elements of contract. So these are some of the things I expect you participants to learn by the time we're done with this module. Then what are the topics we are going to discuss? We'll look at the Nigerian legal system. We'll look at relevant government agencies regulating businesses in Nigeria, types of business organizations and legal implication of the various types of business organization, registration of business organizations, and then finally we'll look at law of contract. So let's start by discussing the Nigerian legal system. So when we talk of the Nigerian legal system, we're talking about the totality of laws, rules, and regulations, and all machineries on ground put in place for the purpose of implementing laws. So when we are when we say the legal system, Nigerian legal system in this sense consists of totality of the laws or legal rules and legal machinery which are obtained within Nigeria as a sovereign country. So when we say the rules, we are talking of all the laws in Nigeria which are derived from the constitution as the ground norm of the land. That's such laws as the penal code, criminal code, uh, Advanced Free Fraud Act, act, so many acts, Karma, Bufia, CBN Act, FIRS Act, all these ones these are the laws. Then when we talk of the machineries put in place for the implementation of such laws, we have the judiciary, we have the courts, we have the various agencies of government and parastatals and paramilitary and the police for the purpose of implementing these laws. So when you look at the legal system, when we talk of the Nigeria, we're talking about the executive, the legislature, and the judiciary, because these will ensure that the law is sustained. So, what is law? When we talk of law, definitely there is like acceptable definition of law. There is no unified definition of law. It means different things to different people. But one thing I know is that all of us will agree to the fact that it's there to regulate behaviors within society, to regulate the conduct of persons within society. And for such laws to regulate the conduct of persons within a particular society, such laws must be acceptable. It must be acceptable by people as binding and backed up by some mechanisms for its sustenance of its binding nature. So first of all, you make set of rules that these are the rules that will govern us as a people. That's why as a family, society, if you go to different organizations, you get to see them, they have different laws. So these laws now, just saying we have these laws without putting down a mechanism for the purpose of implementing such laws, there's going to be a problem because laws cannot exist in vacuum. There must be a way you can implement such laws. That's why we have the police, we have the judiciary, we have the court to these are the mechanisms. We have the government, we have the federal government, we have the state government, we have the local government. Then you come again, you divide the government into the judiciary, the executive, the legislature. So these are the mechanisms there to ensure that these laws are being obeyed and backed up by and sustained by some mechanism. So what are sources of Nigerian laws? When we say sources, these laws that we have in Nigeria were not just manufactured somewhere. They were sourced. Where's the network? Okay. So, sorry for the problem we experienced. We're experiencing a problem. The problem is not from you people or any of the participants. We are not hearing. We had a little technical issue and it's as a result of network. So I believe it's sorted out now. I will continue from where we stopped. This is I stopped. No, I know where I stopped. It's just that this okay, no,
You're back here.
and that's not back. Can you hear me? Okay, you can hear me. So, sorry, we were on sources of Nigerian laws before we were interrupted by network. I apologize for that. So, I was talking about the sources of Nigerian laws. So, I was about network problem. I apologize for that. So, sources of Nigerian laws, we have
slide.
Sorry, back online. I hope I'm back for good this time. So I don't know what's happening. We're just experiencing a serious network challenge. We regret any inconvenience that any of one of you might have suffered as a result of this uh, situation. So I was discussing sources of Nigerian laws we were before the network suddenly went bad and we had serious issue coming back online. So well, these Nigerian laws we're talking about did not just manufactured themselves. We got them from somewhere. So we have the English receipt law. When we talk of the English receipt law, we are talking of the common law and doctrine of equity. When I say common law, it's basically laws based on the custom and traditions of England, of England. It's a law that is developed by the common law courts of England based on the customs and traditions of the people of that realm. So what happened back then in England was that the crown will send out itinerant justice. When I say itinerant justice, that is people that move around, justices that move around from one particular locality to another, administering justice based on the customs and traditions of the people. So after they've done that, they will come back to the capital, London. They will sit and discuss the customs and traditions they encounter. So those traditions and customs that are good, they will just bring those ones and uh, and 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 say, okay, this custom is good. Henceforth, if I'm going to if I come across something like that in another locality, I'm going to use these people's custom to administer whatever case it is I'm experiencing in another custom, which is more justifiable. Then, but over time, the common law became more rigid and became more concerned with form and procedure rather than administering justice. So litigants were not satisfied with the outcome of what they were getting from common law courts. So they began to petition the crown. And once they petitioned the crown, the particular set of people that will entertain that petition were the King's Council. And then the head of the King's Council was the Chancellor, who was a priest back then. So based on his priestly background, he uses that to 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 administer cases. So people that were dissatisfied with the common law will petition the crown. The crown will sit down and look at their cases and say, okay, the fact that this person did not, let's say for instance, common law will tell you that if you want to sell your car, it must be in writing. If you sell the car without putting it in writing, that means if the person does not pay you, you are not entitled to anything. So let's say Mr. A and Mr. B entered into an sale contract of sale for a car, but it was not written. And Mr. B refused to pay Mr. A his money, and they went to common law court. Common law court will say, because you failed to put that agreement in writing, then they cannot hear your case. They will not entertain your matter. So by the time you you petition the crown will look at it based on the remedies, based on the crown will disregard the procedures and form. The crown will not say, okay, because it is not in writing, then you are not entitled to justice. So what will happen is that the crown will say, okay, the fact that it's not in writing, but you've met all the conditions for contract, then because of that, you are entitled to be paid your money. So basically, doctrine of equity is not is what we call these are this thing developed by the court of chancery to mitigate the harshness of common law. Yeah, doctrine of equity was developed by the court of chancery for the purpose of mitigating the harshness experienced by litigants caused by common law. So, doctrine of equity is not fairness as in the usual setting, rather is to mitigate the harshness of common law. So they developed the doctrine of equity. And this common law and doctrine of equity are still applicable to our laws. you will see, because if you see some of our laws in Nigeria, they are not being reviewed or either have they been amended because they are still that common law. And doctrine of equity still plays a major part in our jurisprudence because you will see some of these doctrines like he who comes to equity must come with clean hands, he who seeks equity must do equity. These are some of the maxims that were brought into our law, based imported into our law from the days of when the English people were colonizing Nigeria. Then we go to Nigerian legislation. This one is basically our National Assembly and State House of Assembly making laws, and we know this is something they often do, making laws, passing laws by first reading, second reading, then they will finally assent it. If the president will assent it, then it becomes law. Like recently, the Bovia, the Kama, they recently passed into law. Then we have the customary law. The customary law is basically based on the custom and traditions of the people. It's based on the custom and traditions of a particular setting. A notorious custom is the Benin custom of inheritance. The Benin custom of inheritance is one of the notorious customs that is applicable in Nigeria. So basically, it's the body of laws and regulations administered based on the tradition and customs of the people of that particular setting. I don't know, the Benin custom of inheritance is that the eldest son normally inherits the house the father was living in while he was alive. So if it goes to anywhere, if that particular custom goes to any court in Nigeria, the court will apply the customary law of Benin before when it comes to inheritance, even up to Supreme Court. There's a notorious case for that. That's the case of Idenhem, one of the notorious cases that is used as a precedent for deciding cases in Nigeria. Then we have the judicial precedent and case law. These are, we know that the courts are there to interpret laws, but in the course of interpreting these laws, sometimes they end up making laws for the people. For instance, like let's say uh, it takes section 20 of Karma to, it's just an example, to court for interpretation. What the court interprets that section to be now becomes the law. If court says section 20 is saying you should put your goods in the boot, so then that means that section 20 will forever be interpreted as putting your goods in the boot. But that's what the Supreme Court has interpreted that to mean. So, and once the Supreme Court has interpreted something as that particular thing, that particular section as putting something in the boot, then it becomes the precedent. When I say it becomes the precedent, because the Supreme Court is the highest court of the land, other lower courts are bound by the decision of the Supreme Court. So that decision of the Supreme Court, when other courts experience similar case with similar facts, they are to toe the line of the Supreme Court and saying section 20 is saying put that thing in the boot, not in the car. So that's basically precedent and case law. Then we have international laws. These are laws that govern relationship between different countries, and we have different treaties, conventions, practice, and customs. So these ones also form part of our law. An example of an international treaty that forms or an international convention that form parts of our law, especially Part 4 of our Constitution, is the United Nations Declaration on Human Rights. So that particular this thing form part of and the African Charter on Human Rights, they form part of our Constitution. So international law also plays a major role in sourcing the Nigerian laws, and these laws must be domesticated. Then let's quickly look at, for them to be applicable in Nigeria, let's quickly look at the hierarchy of the Nigerian court. As I said earlier, the Supreme Court is the apex court of the land. Then we have the Court of Appeal, which is the second to Supreme Court. The Supreme Court entertains all matters coming from courts of the superior records of coordinate jurisdiction. The responsibility of the Supreme Court to entertain all those matters on appeal. Then, similar to Court of Appeal, it does entertain appeals from courts of superior jurisdiction. So we have the Federal High Court. The Federal High Court used to be a revenue court, but by virtue of Section 251 of the 1999 Constitution as amended, the Federal High Court now has exclusive jurisdiction to entertain matters listed in that section of the Constitution under paragraph F, matters pertaining to companies and matters relating to administration of companies, matters between companies and corporate affairs commission, federal government agencies, with, other federal government agencies, uh, copyright issues, patent, trademark. So these are all exclusive to the Federal High Court. Then we have the State High Court. The State High Court has unlimited jurisdiction when it comes to civil and criminal matters, but it does not entertain matters that fall within the jurisdiction of the Federal High Court and the National Industrial Court. So the State High Court to entertain different all matters except for the ones that fall within the jurisdiction of the Federal High Court and the National Industrial Court. Then we have the National Industrial Court. The National Industrial Court is there for the purpose of entertaining matters relating to trade unions, labor unions, master servant relationship, anything pertaining employment is within the jurisdiction of the industrial court. Then we have the Sharia court. The Sharia court is there to entertain matters of people who are subject to Islamic personal law. So the Sharia court is there for them. Then we have the customary court to entertain matters relating to custom of people of that particular setting, as I used the Benin custom as an example. So it's one of them. Then we have the magistrate court. The magistrate court is a court of inferior jurisdiction, summary jurisdiction. It has jurisdiction to entertain civil and criminal matters. Only that it has limited jurisdiction, as it's not all matters that can be entertained by the magistrate court. And we also have the area court. The area courts are similar to the customary court, just a matter of nomenclature. Because in the north, the customary courts are referred to as area courts. Then let's quickly look at civil law. When we talk of civil law, the civil law is it serves to regulate the conduct of persons in their interpersonal dealings and conferring status and rights and obligations on individuals or juristic persons. So civil law is basically there to regulate your relationship with private citizens. When your rights are violated by the citizen, then you can go to court and sue and obtain damages. So let's say transfers, battery, defamation, all these are examples of civil wrong. These are not criminal matters. When I say civil wrong, that means the person is entitled to damages. You cannot, they are not statutorily, most of them are not statutorily covered. Most of them are decided based on decided cases, civil law. And civil law is such that you cannot lock the person in. One of the remedies is unlike criminal law, you cannot say they cannot sentence the person to serve prison time or anything. Normally, the remedies are damages, specific performance, rescission, rectification, which we will look at subsequently when we're talking of contracts. Then, criminal law. Like criminal law is, even though it's not on the slide here, but it's something we need to discuss because it's part of the Nigerian legal system. Criminal law is a body of law that relates to crime. It prescribes a conduct. That means a conduct, it says that a particular conduct is not right. So once you commit such conduct, you are committing a crime. So that's what criminal law does. That's why there are certain things we do, even though you do it like murder, you commit it against a person, but because it is written and prescribed that once you kill someone, you committed an offense and there is a sentence for that, which could be death, which could be life imprisonment, even though you are committing it against somebody, it is being committed against the state. Usually they are statutory. So a person should by virtue of section 35 of 11 of 1999 Constitution as amended, says for anybody to be punished for an offense, that offense must have been written and punishment prescribed, and the penalty prescribed in the written law. If not, that person cannot be charged with that particular crime. And the main objective of criminal law is to punish wrongdoers, thereby seeking to protect the collective interests of citizens against detrimental conduct of its constituent members. So, so basically, this is just on the Nigerian legal system. So let's look at relevant government agencies. What are the relevant regulatory government agencies regulating business in Nigeria? We have the Corporate Affairs Commission. We'll look at that in detail later. We have the Federal Inland Revenue Service. We'll look at that subsequently in detail. And we have the Central Bank of Nigeria, which is the CBN. You know, the CBN is the apex financial institution in Nigeria. The CBN is there to ensure that the economy of Nigeria is moving smoothly, and the way banking is done in Nigeria is also smooth, and it ensures that there is liquidity flow in the Nigerian financial system. So the CBN is the bank of last resort. That means where there are issues within the financial institution, the CBN is there to always bail out banks in collaboration with other agencies like the NDIC and others. So the CBN is there to ensure that there is economic growth in Nigeria. For instance, the CBN is rolling out different programs. Just for this particular program that you are undergoing training for is an example of program that is rolled out by CBN for the purpose of ensuring that there is growth in the economy. Then we have the Asset Management Corporation of Nigeria, which was established by the AMCOM Act of 2010. The purpose of AMCOM is to ensure liquidity flow in the Nigerian financial system. So AMCON is just there to buy off bad debt, non-performing loans from banks. Let me give you an example. Let's say Mr. A went to GT Bank and borrowed money, and because he borrowed that money from GT, he has been unable to repay the loan. So that will affect the balance of the GT's balance sheet. So what AMCOM normally does is it will go to such banks, request for their balance sheet, look at it. If there are debts that are affecting the liquidity flow in the bank, AMCOM will buy off that debt. Let's say Mr. A's debt with GT, AMCOM will buy off the debt. And instead of instead of Mr. A indebted to GT, he will now be indebted to AMCOM. So AMCOM will go after him for their money. Then we have the standard organization. We have NAFDAC, which we also look at in detail subsequently. Standard Organization of Nigeria, and Federal Capital Development Territory. Also we look at which is FCDA. If you're into a business that has to do with land, you know the appropriate authority you need to approach if you're in the FCD for the purpose of buying land or obtaining land for that particular business you intend to engage in. And if you're in other states, you know you have to approach the state commissioner for lands and other agencies responsible in that state for doing that. The Corporate Affairs Commission, which I earlier said we'll look at in detail, was established by the Companies Allied Matters Act of 1990. And I believe you are aware that the CAMA has been amended severally, and the recent amendment is the 2020 amendment, which brought in some changes, very vital changes, and some changes people think are not necessary, though this is not part of what we are here to discuss. So it is a regulatory agency in charge of registration and regulation of business. That means uh, organizations which are into profit making, and non-business organizations. Non-business organizations such as churches, mosques, non-governmental organizations. So these are the things. Then we have Section 7 sub 1 of CAMA. It sets out the main function of CAC, which include regulation and supervision of the formation. We want to form a company right now. CAC plays a vital role to ensure your company comes to fruition, that your company engages in incorporation. You have to incorporate your company with CAC first. Then you have the management. After you incorporate the company, CAC still plays a role in the management of that company because you need to be filing your annual returns to show CAC that is a going concern. Then, in case you feel you are tired of running the business, you want to wind the company up, the appropriate this thing to approach is still CAC. There are procedures laid down for winding up. Then we have the power to carry out investigation into the affairs of the company. Once you are registering a company, CAC will ask you for the objects of the company or purpose of why you are registering that particular company. If in the course of running the company or that NGO is CAC discovered is you are not running it in accordance to the object you supply to them while incorporating your company, CAC has that power to investigate into the affairs, and if the situation demands to take that particular organization to court, then if it is an NGO, take over, appoint new trustees, if it's a company, appoint new directors, if it is a business, name, appoint new proprietors. So this is case. Let's quickly look at the Federal Inland Revenue Service. The Federal Inland Revenue Service used to be an arm of the Federal Board of Inland Revenue. Federal Board of Inland Federal Board. It used to be an arm of the Federal Board of Inland Revenue, that is the FBIR. So, however, by virtue of the 2013 Act, by virtue of the 2007 Act of the FIRS was established as an autonomous organ of the Federal Inland Board Revenue. So, as a result of that, it became autonomous. What the FIBR does for FIRS is just to roll out general policy. So it's the function of the responsibility of IRS is the collection of an administration, the administration and collection of federal and corporate taxes. All existing manufacturers, distributors, and importers and suppliers of goods and services are to register with with FIRS for VAT. Before we discuss VAT, other responsibilities of FIRS include to control and administer the different tax enactments. That means by virtue of Section 25, Section 2 of the Act establishing the FIRS, and by virtue of Section 25 of the Act establishing the FIRS is to administer and enforce the various tax enactments too. And once we are talking of these tax enactments, we are talking of Personal Income Tax Act, Companies Income Tax Act, Stamp Duty Act. We're talking of the Value Added Tax Act. So all these are within the purview of FIRS to administer. Even though when it comes to the issue of recent controversy between FIRS and NIPOS when it comes to stamp duty. So the issue is still not settled yet. I guess they are still in court to determine who has the right to collect stamp duty on behalf of the federal government. So for the purpose of this class, we'll quickly look at VAT, value added tax. So what is value added tax? Value added tax is the consumption tax levied on a product or service that is offered repeatedly. So once you are running a business, you must charge VAT. As long as you are offering any service or any product, you are selling any product, you must charge VAT to remit to the federal government. It could be weekly, it could be monthly, depending on how you registered with your local VAT office. And your local VAT office is the FIRS office nearest to you or to your business that you registered with the purpose of remitting your VAT to them. Though it's not every product that is vatable, but if you check the Finance Act of 2019, you get to see which products are vatable and which one. But mostly when you are selling products, most items, provision and rest. That's why when you go to supermarkets and the rest, you will see they are being billed for VAT repeatedly. Whether you buy it once, twice, they will still ask you for VAT several times. So same when you are providing a service. So however, when you are into cultivation of processed agricultural produce are exempted from VAT and enjoy pioneer status, so are largely exempted from federal taxes. The registration with Standard Organization of Nigeria. So, Standard Organization of Nigeria is a statutory body that is vested with responsibility of standardizing and regulating the quality of products in Nigeria. And the function of the organization includes to investigate the quality of facilities and materials, to ensure reference standards for calibration, comply and inventory of products referenced, and foster interest in the recommendation and maintenance of acceptable standards by industry and general, register and regulate standard marks and specifications to advise state and federal departments of government on specific programs as contained on this slide. So what are the procedure of registration with Standard Organization of Nigeria? They have two procedures, which is the e-product registration, whereby you go online and you register with them. Then they have the MANCAP, which is the mandatory assessment conformity, conformity assessment procedure. These are the mandatory conformity assessment procedure is for locally manufactured goods, while you go for the E procedure is for the purpose of goods that are listed in their inventory for you to see. So if you are dealing with goods that are within the inventory of Standard Organization of Nigeria to administer, then you have to register with them. And the procedure of registration is what I just called that the E procedure and the mandatory conformity assessment program, which is developed by Standard Organization of Nigeria for the purpose of checking and assessing locally manufactured products. They also have an export guide for uh, for for goods being shipped into Nigeria. So this program is known as the Standard Organization of Nigeria Conformity Assessment Program. So if you want to ship any product in Nigeria, you can log on to www.cortina.com, or you could just Google export guides to Nigeria. So it will get to give you what are those products you need to register with the Standard Organization of Nigeria before you can ship them into Nigeria, or before, or any locally manufactured product you are into the manufacturer. You need to call them to assess, for them to assess the standard, whether it has met the market standard before you could roll it out to the market. So this is basically the work of the Standard Organization of Nigeria. So and it's not all products that are administered by Standard Organization of Nigeria, contrary to what is contained on in the slide here, like all products. No, it's not all products. There are inventory of products that if you go to their site, you get to see. You cannot speak of product and discuss because time is not on our side, and moreover, the network problem will be experiencing also has also really affected us. So let's look at registration with NAFDAC. Registration with NAFDAC. NAFDAC has the mandate to regulate and control the qualities of standard of food products and medical devices. So all business dealing in food related products are to so so NAFDAC is there to control this product. So if you go to the NAFDAC Act, you get to see some of the products that are within the categories of products for NAFDAC to administer, such as foods and drugs, medical devices, cosmetics, narcotics, and the rest, vaccines. So these are products that are within the categories of products for NAFDAC to administer. So once you are into the production or distribution or advertising or anything meant for like drugs, food that are within the categories of products for NAFDAC to administer, then they are meant to register those products with NAFDAC. So NAFDAC, once if you don't register with NAFDAC, the problem is your product will not be market. It will really affect the sale one, and one people would think it's counterfeit. So it's important for you to register those products with NAFDAC. And basically, the registration procedure with NAFDAC it differs depending on the category of product you want to register. And we cannot pick each product, water and food and the rest, and say we want to discuss. So though the different this thing may vary, there are specific documentation that is general to all procedure. And that specific documentation that is general is one application for approval to bring in samples, then application for full registration of product, then application to bring in samples, then application for full product. So for the purpose of this class, we just look at what are the requirements for registration of drug in NAFDAC. It's not all drug. It's just we are looking at medication, drugs generally. We are not saying we are going to pick one drug. Pick if you want to. Basically, if you want to register, if you are into the distribution or manufacture of a particular drug for, let's say, headache or something, definitely if you go to apply at NAFDAC, the procedure would differ from the one for, let's say, chest pain and the rest, though the procedure is generally the same. So one thing you need to know is that uh, one of the key requirements is for drugs, you need to know that application is on a single product basis. When you say application is on a single product basis, basically we're just saying you cannot apply for one NAFDAC number for two different products. Let's say food, you are into production of biscuits and you have different categories of biscuits, or you are into production of food and as well into the production of sachet water. You cannot just apply to NAFDAC that okay, they should issue a registration, they should register the two products for you and issue one registration number. Application has to be on a single product basis. Then written application stating the name of the manufacturer, brand if applicable. You complete the NAFDAC application, certificate of incorporation with the Corporate Affairs Commission, 5 copies of the product dossier. When I say 5 copies of the product dossier, you know that because of your manufacturing or the company you intend to distribute their product, in the course of production, they must have carried out research, they must have done clinical trials, they must have done. So you need to attach all these documents to NAFDAC for them to any license you needed to obtain before you begin the distribution of this drug. You need to attach them to your application to NAFDAC to show NAFDAC that yes, you have this drug is fit for consumption. So 3 packs of the product samples, notarized original copy of duly executed power of attorney from the product manufacturer. Let's say, for instance, we are importing. We know that recently there is a vaccine for corona. Let's say you want to import the vaccine from you want to import the vaccine from London to You want to import. Okay. Sorry, I just quickly want to switch the system. Just a minute. All right, I'm back. So, well, I'm using the corona vaccine as an example of something you want to import from England. Let's say you want to import that particular vaccine from England, and one of the companies that developed that vaccine is the biotech, one company named Biotech. So you need power of attorney from Biotech to the fact that they've given you authority to import that vaccine to Nigeria and distribute it in Nigeria. So they will need to give you a power of attorney. So that's what this power of attorney does. It gives you, it shows that you have the authority. It's just basically in writing, it's just a document containing statement like, okay, we've given so person authority to distribute this vaccine in Nigeria. So what NAFDAC is saying that such document must be notarized. So you can go to any Nigerian embassy go to the Nigerian High Commission in London for them to notarize. For instance, if there is no Nigerian High Commission in London, you can go to any ECOWAS mission too to notarize same. If if there is no ECOWAS mission, then you can go to any British this thing commission or embassy to notarize that particular document. Then there is also what we call the contract manufacturing agreement. The contract manufacturing agreement is just an agreement you entered with the company that okay, you want to be distributing or you want to manufacture that particular vaccine in Nigeria. So you need to notarize the contract manufacturing agreement also, and it must be executed by parties. Remember that NAFDAC is also responsible for uh, supervising the distribution of products. So if you want to run a pharmacy, you also need to obtain license from NAFDAC. So I just quickly listed some of the things you need to submit to NAFDAC for the purpose of obtaining your license. Things like the certificate of pharmaceutical products, current pretended pharmacist license to practice, premises registration license, certification of registration of brand name with trade mark registry. So this certificate of registration of brand name applies to when you want to manufacture or you want to import. Because especially when it's a brand name, you need to register your trademark with the Ministry of Trade and Commerce here in Nigeria. Then you pay the applicable fee and documents. When the documents are satisfactory, uh, NAFDAC would issue a certificate. So these things you might be thinking, oh, this if there are agents that are available to help you run this kind of registration when you are ready, or you could just approach the NAFDAC office at Zone 7. They will also put you through. They will help you do all what you need. Then NAFDAC also has a e-registration procedure, and they call that the NAFDAC automated it's called the NAFDAC Automated Product Administration and Monitoring System, NAPAMS. So you go to www.napams.org, you sign up, you register an account, you will log in. After logging in with your registered account, it will come out with the list of products. So depending on the product you want to register, And you must have met the preconditions for if, for the registration. If you are importing, you must have obtained all those documents you need, because you need to attach and upload. So all those things you need to do before the registration. Make sure you've done them. Then you log in, complete your form, you make payment, you choose the most convenient means of payment. Uh, then after you've made your payment, you process your application, you obtain certificate. As I said, these are things that if you can't do, you can, for further information, you can contact NAFDAC office at Zone 7 or anywhere you are located, or you could just enlist the help of people, lawyers especially, are always there to help you, and you can do the running around for you if you can't do it. All you need to do is just to pay for the professional fees. So let's look at types of business organization and the legal implication of the various types. So, what is a business organization? When we say business organization, we are talking of any legitimate venture to make profit. Any legitimate venture to make. It must be legitimate. It must not be an illegitimate venture. Rather, it must be a legitimate venture to make profit. Then, what are the types of business organization? We have the sole proprietorship, we have partnership, we have company. When we say sole proprietorship, we are talking of one man business, a business being run by one man. He takes his decision alone. He spends the money alone. He decides on how to run the business. He does everything alone. But what are the implications of running a sole proprietorship? What is the legal implication? We know one of the implications is that once he dies with the business. If he dies with the business. And where he takes loan, for instance, from banks, let's say Mr. Johnson is the owner of Johnson Business Venture. This is a business Mr. Johnson is running as a sole proprietor, and he decides to borrow money from GT Bank. The fact that he borrowed money from GT Bank and is unable to pay the money, GT Bank went to court, obtained judgment. If GT want to enforce that judgment, they can come after him personally. They will come after his belongings, his car, his everything, his household stuffs, anything he owns, they will come after it. So this is basically what running the legal implication of running a sole proprietorship. The business, you are not separate from the business. There is no this personality, separate legal personality, unlike companies and limited partnership. Then let's look at partnership. Partnership is when two or more persons come together to run a business together for the purpose of making profit. And partners can be limited and they can be general partners. Limited partners in the sense that when we say partnership is general, when two or more persons come together and say they want to be involved in the day-to-day running of the business. For instance, Mr. John and Mr. Johnson decide they want to form partnership, but they want to but both of them want to they want to partake in the day-to-day running of that business. For the fact that they all want to partake in the day-to-day running of that business, it makes them to be general partners. And one of the implications of being a general partner in a partnership is that you risk uh, 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 having your personal belongings seized for the purpose of offsetting any debt and liabilities of the business. You go and borrow money. Mr. Johnson and Mr. John, as general partners, went ahead and borrowed money from a bank, from a financial institution. So, if the financial institution is to come for its debt, it's going to go after both Mr. Johnson and the personal belongings of Mr. Johnson and Mr. John. That's the legal implication of being a general partner. So, whereas if you're a limited partner, it does not apply that way. If you're a limited partner, your what those financial institutions will come after is your investment in the business. That's your limited investment in the business. That is what the financial partners will come after. So your liability is just limited to the amount of investment you have in that partnership. For instance, now Mr. John and Mr. Johnson said, yes, he wants to be part of the business, but he just wants to invest and sit down. He doesn't want to be involved in the day-to-day running of the business. So that makes Mr. Johnson a limited partner. So if Mr. John goes ahead to borrow money in the name of the business and they were unable to finance the debt or the loan they borrowed to service the loan or the debt, eventually the bank is coming for its money or that particular financial. For Mr. Johnson, it's only his investment in the business the bank will come for. But as for Mr. John, who is involved in the day-to-day running of the business, the financial institution will come after him personally, his personal belongings and the rest. And you need to know something about partnership. If you are running a partnership, you must be involved in the sharing of the profit. If not, if you are not involved in the sharing of the profit, you don't regard yourself as a partner. But normally, profits has to be shared equally. But partners is not by partners, but it's not necessary because except agreed otherwise. Who is a partner in is whether the person partakes in profit sharing. So if you are running a partnership and you don't partake, you are running a partnership quote and quote with your partners and you don't participate in the profit sharing, you are not a partner in that business. Then companies and its legal implication. There is something unique about company, just like limited partner. Like Mr. Johnson now, who is running Johnson Business Venture as a business name, as a sole proprietor, decides that he wants to upgrade to a company. So the day they issue certificate of incorporation to Mr. Johnson with respect to his company that he registered, Johnson and Johnson Limited, Mr. Johnson becomes a separate uh, personality from Johnson and Johnson Limited. Johnson and Johnson Limited in law will be regarded as an artificial person, while Mr. Johnson will be regarded as a natural person. So by so doing, the company is separate from Mr. Johnson. You see, unlike sole proprietorship, where even if you register with CAC and you are running a sole proprietorship in the name of business name, they will still come after your personal belongings. But in the case of a company, high as Mr. Johnson can be in that company, either he's a director or a shareholder. And being a shareholder, his liability is limited to his investment in the company. So as a shareholder, they cannot come after his personal assets. They can only seize the debts and liabilities of the company. So when, let's say, the company borrows money from a financial institution and they are unable to service it, and the company has different properties around the country, so the bank will go attaching these properties because it belongs. They will not come after any of Mr. Johnson's personal property. His property that he acquired is in his name. Rather, the financial institution will go after all those uh, all those properties bought in the company's name. So the company being a human being of its own, that is Johnson and Johnson Limited, it can do any of the following. It can buy and own properties. It can enter into contract. It can sue and be sued. That means that's why you see some companies going to court. It enjoys perpetual succession. That means it lives forever. I like to use First Bank when I come to this lives enjoys perpetual succession. If you check the logo of First Bank, you see since 1894. So are we saying that since 1894, the people that began First Bank are still alive, or the initial shareholders, the the initial directors? No, because First Bank is an artificial person. Directors will come and go, shareholders will come and go, and the rest, and it lives forever. So when you decide to register, that's one of the advantage of registering a company. The fact that you are the one who started the company. Anytime you feel like you don't want to run this company anymore, you can just withdraw and leave and sell your shares in the company and leave anything regarding the company. It becomes none of your business. Then you can apply for loan in its registered name. So let's quickly look at registration of business and non-business organizations. Why register your business? Why do you have to register your business? Because initially we said registration of business is done with the corporate affairs. So why do you have to register your business? Or if why did you register your business if you have a business that is registered and you just did it for the sake of I want my business registered, but subconsciously you did it with the fact that you want to obtain loans from bank and you want to benefit from some certain corporate and fiscal product registration. First of all, if your business is not registered with the CAC, you don't even stand a chance of getting a loan from a bank because they will conduct search to see whether that business is registered with the CAC. Then another thing is they will look at whether uh, one reason for you to register your business is that there are uh, some 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 incentives that might be available to businesses that might be made available by international organizations, federal government for businesses. But the criteria for accessing such facilities will be your business must be registered and you must be paying your tax. For instance, the federal government survival fund. So if you have a business and it's not registered and you are not paying your tax, then tell me how can you access such facilities? So registration for tax is also an important social responsibility. So let's quickly look at small business startup procedure. When we say small business startup procedure, what are the things you need to do if you want to start up a business? First of all, you find a suitable business name to support your business idea. The name must be easy to pronounce, remember, and has relationship with the type of business you are running. You identify a suitable business location. When we say you identify a suitable business location, is that particular service or product you want to offer, is it being offered by other vendors, or is, for you to choose that particular location, there must be a reason. And even though there are other vendors supplying or providing that kind of service you intend to offer, what edge do you have over them and you think people will patronize you rather than those people? So these are things you need to look at. Register with the Federal Inland Revenue Service for the purpose of collection of your value added tax. Then if the products are products that fall within the category of product that has to be registered with either NAFDAC or Standard Organization of Nigeria, then you need to do that registration too, especially when you are dealing with foods and drugs and other related items. Because you know that people are always conscious of before buying anything, is there a NAFDAC registration number of that product? In the absence of that, it will really affect your market. Then procedure of documents to be submitted to CAC for registration of a business name. Before, we talk of sole proprietorship, we talked about partnership, we talked about companies. So let's say you want to register, you run a sole proprietorship or you run a partnership, you want to register it with the CAC. You can register it as a business name. As a business name, that means you guys will be proprietors. So that is what we want to look at. Let's say you want to register that particular business that you are running with your partners as a business name with the Corporate Affairs Commission. What are the procedures and what are those documents you need to submit to CAC for the purpose of registration of that business name? One thing you need to know that before you register with CAC, if you are not an accredited agent, because CAC have people they accredit to carry out registration on behalf of their customers. But they've introduced a method whereby a customer can also do his registration by himself. Let's say you want to be a proprietor in your own business name, you can go to their site. There's a procedure where you go to their site, you register, open an account, and begin your registration yourself. But where you cannot do it yourself, there are accredited agents. These are lawyers, chartered secretaries, uh, chartered accountants. They normally carry their accredited identity card with CAC, and they have designated portal carrying their names and their ID number for them to carry out that registration. So you as an individual or as a proprietor or as a director of company or as a shareholder of the company, you decide you want to register it yourself. You don't want to use an agent. You must go to their site and register first as to create an account. for the purpose of doing that registration. Let's say you've gotten that account, then you've gotten the name of the business name you want to register. For instance, Mr. Johnson who wants to register Johnson Business Venture. First of all, he will need to look at certain things for you to submit that name for approval to CAC. You need to look at whether is the name similar to another name, is the name in use, is the name a restricted name, is the name uh, is the name a restricted name? Is the name another thing you need to look at is the name carrying Abuja or international organization? Because these are things that if CAC looks at and they discovered that this the name is in contravention with their guidelines, they will not approve the name for you. The good news is that before you put that name, you will see it will bring out options of names that you cannot use. So once you put in the name, CAC will look at the name. Let's say Mr. Johnson Business Ventures. It's not a restricted name. It's in line with their guidelines. CAC will approve the name. They will send to Mr. Johnson a message that the name he submitted has been approved and reserved for him for 60 days. So he's to carry out his application within 60 days and he should make payment within these 60 days. Then he will state the nature. So once he he uh, he uh, once he's sent that message by CAC and he's in receipt of such message, the message will carry a code. That code will enable him to begin his registration. He will enter details like his name, nature of business, uh, uh, the nature of the business, who are the proprietors of the business, or who is the proprietor, where you have more than one proprietor. You state the information. You need your means of identification, either your national identity card, either your voter's card or international passport, and your two photo passport size photograph. So you need those things in place before you begin your registration because you need to enter the details of your means of identification. Then after you enter all necessary details, you make payment. Payment are in two stages. Payment when you are reserving your name, payment for registration where remitter will also charge you for the services they offered you. So once you are done, you download the form, you sign, then you upload the form. In uploading the form, you upload the notice of approval that was sent to your portal by CAC. So you need to download that. You upload the fees you paid, the registration fee. You upload that. Then your registration form, you also upload that to CAC. So once you upload it, there is a provision on their site for uploading these documents. You look at them. If there is no problem, they will approve your business name. Your business name is registered and you go and collect your certificate. So similar procedure is applicable to when you want to register a company. Only that in the same when you want to register a company, you know that we have different types of companies. One, we have the private limited company, we have the public limited company, we have the unlimited company, we have the company limited by guarantee. But for the purpose of this class, and considering that most of you will go into small businesses, it's advisable you run a private limited company for 2 to 50 shareholders based on the old karma. But with the new karma, it says that one person can register a company. One sole person can be the shareholder, he can be the director. That is by this new 2020 karma. However, CAC are yet to begin the implementation of the new karma. So they are still applying the old karma. So if you want to register your company, you don't want to use any of the agents available. First of all, you need to know that you need, for your own sake and for the business you want to run, you need to register a private limited company. After you've done your research, the name you want to get, what we discussed earlier on startup procedure, you've gotten the name, reservation of name, just like the way it is with a business name. That's how it is with companies. And you need to know one thing with private limited company, you must have at least with this old karma provision, you must have at least two directors and at least two shareholders. But for unlimited company, it's also applicable, but the shareholders are unlimited for public limited company, unlike private limited companies. And public limited companies are usually quoted on the stock exchange. The fact that you begin with a private limited company does not mean eventually you cannot convert your company to something, to either a private limited, to either a public limited company. Public limited company they normally have shareholders and they are quite big companies. So let's say you have gotten the name of the company. This next step is reservation of the proposed name, and the name must be in line with the guidelines, and it must carry limited. That particular name you want to register with CAC, that company name you want to must carry limited. If not, CAC will not allow you to proceed with the application. So once you enter the name and the name is approved, they will send a mail to you that the name has been approved. Then they will, the same with a business name, they will send a code to you, your portal for you to download, which is the availability uh, uh, code. It will carry the availability code. You enter the availability code, which will direct you to where you are supposed to begin your registration. And the name will be reserved for 60 days, just like business name. And you have to carry out your registration and make payment within that 60 days. If not, you are going to lose the name reserved, and whatever information you entered on that page, you also lost that particular information. So let me give you an example of what you first of all encounter. First of all, the first page you will see if you want to register with CAC is the name of the company, the share capital of the company, how you intend to share the share capital. Normally, in Kama, the old Kama, it will tell you that the minimum share capital for private limited company is 10,000, for public limited company is 50,000. But due to guidelines and changing the naira value and policies and the rest, see the minimum share capital CAC will take is 1 million share capital. And 1 million does not mean you're going to pay CAC 1 million. You're just telling CAC that your company is valued at 1 million share capital. That is just an artificial valuation of your company. So you enter those details, you enter the address of the company, you enter the directors of the company, who are the shareholders of the company, you enter the objects of the company, and there are articles of association for you to adopt. Objects of the company is just telling CC this is what the company intends, and memorandum of association carries the object of the company. It will tell people, it regulates the relationship with the company or with outsiders, while the article of association regulates the relationship of the company generally. So when you look at your information, you filled everything correctly, and you need your data page of international passport, driver's license, voters card of all the directors and shareholders, because you will need to put the number while filling the form. So if you are done, you make payment just like business name at two stages: when you are reserving it and when you fill the form for the companies. You make payments, remitter charges to will apply, you make payment, you download the form, then you sign where you are supposed to. Directors will sign, the shareholders will sign. Then just like business name, there's a place where you go and upload the the names. So you just go to that particular place, you upload all the documents needed. CSC will give it a look. If there is no problem, no query, it will approve, and you go and obtain your certificate. So basically, these are just the procedures of documents to be submitted to CSC for registration of company. This is just a sample of fees. Registration of companies under Part A of Karma is just a sample. These are not the fees that are obtainable now. It's just for the purpose of this class to give you an idea of the fees and the rest. So because time is against us, let's quickly go to law of contract, which is the last topic we are going to look at. So when we say law of contract, we are just law of contract itself is quite vast. because the textbook alone, the Nigerian textbook written by Sage is like up to 400 pages or 500 or 600 pages. I'm not mistaken. Then we have the the Nigerian test, the foreign textbook by Chiti. That one too is quite large, and there are other lots of textbooks. So what I'm just doing here is just for you to have an idea of what law of contract is, because basically when you register your company, what you definitely do with that company is that you'll be entering into contract for the purpose of buying and selling. And contract does not mean parties must sit down and write. So once we discuss this, you get to know contract is quite vast. So when we talk of contract, we are talking of an enforceable legal obligation agreed upon by parties. There must be agreement by parties to the fact that yes, this is uh, they want to enter into that contract. Then what are the elements of contract? We have offer. What when we say offer, basically we are looking at you making an offer to somebody. Yes, it's offer, but in law there are various kinds of offer. Like if you walk into the supermarket, you see them displaying their products. That is what we call in law of contract invitation to trade. So once you pick that product from the shelf and you approach the cashier, that is you making an offer to the cashier. You're making an offer to the cashier. So once there's that offer, then there is contracts. You know where you see in newspapers they're advertising invitation to tender. So companies and government parastatals calling for invitation to tender. That is what we call invitation to trade in law of contract. So when you submit your application for the contract to be awarded to you, that is you making an offer. And for every offer, there must be an acceptance. So that's the next element of contract. There must be an acceptance. For instance, Mr. Johnson wants to sell his car to Mr. John. You know, he offers his messages to Mr. John. Mr. John must have agreed to buy the car. So there is acceptance. Then the next thing is consideration. That is a thing of value must exchange hand. That is money must exchange hand, or depending on what they want to use as a thing of value, then mostly is money. So once there is exchange of money, no matter the amount exchanged, it must not be the full payment. It might be a part payment of the the larger sum. So it's still consideration. And there's this what we call consideration is past in law of contract. When we say consideration is past, once you agree with a party that you are selling that product for 5 naira, and later you discover that the product goes even for a higher amount than 5 naira, you cannot come back and say, no, I want to. That is what we consider consideration is past. The other elements include form. Contract can be in writing, can be oral, and it can be by conduct. It must not be in writing, even though the law says that there are some contracts that you must have them in writing under the law of contract. But contract too can be orally, it can be by conduct. By conduct, example is you can just board a taxi without even saying a word, but you know where that taxi's last bus stop is. So immediately you drop at the last bus stop, you just pay the taxi man, knowing fully that okay, this is the amount. Then we have what we call capacity. If you are entering into contract, you must have that capacity to enter into that contract. For instance, you cannot enter into a contract with somebody that is mentally challenged, somebody that is drunk, somebody that is a minor, even though there are exceptions when it comes to uh, drunk, mentally challenged, and a minor. Mentally challenged persons, there's times that they experience their lucid period, moments where they are sane, they experience brief sanity. So at that period, if it is established that that person has such periods and he enters into a contract, that contract will be considered as valid. As for a minor, where he enters into contract for the purpose of purchasing his necessities, that contract, even though he's a minor, that contract is valid. Then we have legality. A contract must be legal. As we said initially, is an enforceable legal obligation. You cannot go to court and say you want to enforce a contract that in the first place is not even legal in Nigeria. For instance, a prostitute cannot say she wants to go to court and enforce a contract she had with with her client, and because the client is supposed to pay her for uh, 5 nights and he paid her for 3 nights. Such contracts are not illegal, or snatching of ballot box on the basis that you paid money. If you are not paid that money, you cannot go to court and say you want to enforce such contract. And there must be intention to create legal obligation. Parties must be willing to create that in legal obligation. It must not be by under duress or undue influence or by anything that you were made to enter the contract. So let's quickly look at privity of contract. When we say privity of contract, we're simply saying only parties to a contract can sue. If you're not party to a contract, you cannot sue. Mr. Johnson sold something to Mr. John, and that particular thing is not in good shape. Mr. John's wife decided to sue Mr. Johnson. That is not the case because she can't sue because she's not privy to that contract. Only parties who are privy to, who are part of the contract can sue. Though this is just a general principle, there are exceptions to privity of contract, especially when it comes to covenants running on land. That means you live in an estate, then you sold your property to somebody in that estate. You know, you are no longer, the contract is between you and the person you sold your property to. But you know, at the time you were buying the property from the estate management, there are some covenants you entered into restricting you from doing certain things in the estate. Then that person you sold that property to decides to do some of that things that he's not supposed to do in the estate. So the estate management have a right to sue that person even though they were not party to the contract. So this is just an exception. In terms of contract, when we say terms of contract, contract is just basically writing, stating what parties intend, stating the party's intention. That means this is a contract dated. I'll just give you an example. 5th of July between Mr. A, who is hereby referred to as parties. It is agreed as follows. You state what the agreement is. That's basically contract. If it is sale of car, you say it's for sale of car, and it is agreed that the car will be in perfect condition. The car will move from area 1 to area 2. The car will go from this, that. The tires must be in perfect condition. The brake must be working. This thing is working, and it's agreed that you sell the car for 50 million. So this is just express terms. They are written for everything. But there are some terms that might not be expressed, but they can be implied sometimes. Following from the express term, you just imply them that okay, these terms basically by the time you sold this car to this person, even though it is not contained in the agreement that it should be going to area 1 to area 2, it is implied that the purpose of buying the car is to move around. And if the car does not move around, basically the contract is defeated. So that term will be implied. What are the vitiating elements in a contract? What are those things that can vitiate a contract? We have duress and undue influence. Duress is where you use threat of violence on somebody. That if he does not enter into that contract, you are going to beat him, or you are going to beat his relation, or you do something that will be harmful to him. You force him to enter. And duress can be economic too. Duress can be you have a financial advantage over that person, and you tell him if he doesn't enter this contract, that money that you are supposed to give him for that other contract, which he did not do, you will not. So that's also duress. Then we have undue influence, where you influence somebody to enter into a contract. That contract will be regarded as invalid, especially when there is a fiduciary relationship between you and that person. You will have superior knowledge on that particular thing you influence him to enter into contract with. That contract will be regarded as vitiated, as invalid, as null and void. Misrepresentation is just when you misrepresent facts. You did not state the true position of the contract at the time before or at the time of entering the contract. Mr. Johnson wants to sell his car to Mr. John. He says the car is mileage is 5,000, and whereas mileage is 53,000, the tires are not in good. He misrepresents everything about the car. So, and Mr. John paid for the car before even seeing the car, or he did not discover some things until he took the car to his mechanic. Then he discovered that as long as he can prove that Mr. Johnson misrepresented certain facts to him about that car in court, that contract will be vitiated. Then we have mistake. When we say mistake, we are saying that the subject matter of the contract is no longer in existence. That means the subject matter which parties are entering into the contract is no longer in existence. Is mistake. Mistake can also be where a party are mistaken as to what product is being offered for sale. Let's say Mr. Johnson wants to sell his Mercedes and BMW for 100,000. Mr. John thought that okay, is the BMW. He wants to sell BMW for 100,000, Mercedes for 100,000. Then Mr. Johnson thought he's selling the two cars for 100,000, and he ends up paying 100,000. So the law will say there's a mistake because what Mr. John intended was the Mercedes for 100, the BMW for 100, not both cars. So that contract will also be vitiated by virtue of mistake. Then what are the ways to discharge a contract? Contract can be basically discharged by performance when both parties have discharged their obligation under the contract. Mr. Johnson has a car, he sold the car is in perfect condition. Mr. John pays the money for the car. Parties have discharged their obligation under the contract. So parties are no longer under any obligation to anybody. Then we have frustration. Frustration is just like the example of mistake I used earlier, when the subject matter of the contract is no longer in existence. Mr. Johnson and Mr. John are talking about buying a filling station in Gwagwalada. Unknown to them, the filling station in Gwagwalada has been burned down at the time of making the negotiation and making payment. Such a case, that is frustration. Such contract will be said to be discharged. And where there is breach of the breach of fundamental term of the contract, that also will affect the contract. For instance, where you order for an iPhone from Jumia and they supply you with HTC, you see there's a breach of the fundamental term of the contract. And in such a case, such contract will be vitiated by virtue of the fact that they are in breach of the term of the contract. Because that lack of supply of iPhone to you is fundamental to the contract. And we have mutual agreements where parties will just, even though none of the parties have discharged their obligation, will decide that okay, they don't they don't they don't want to perform the contract anymore. Then they will mutually agree that okay, let's discharge. Then finally, under contract, we are going to look at what are the remedies available to parties when the contract is breached. Mr. Johnson is in breach of the contract. He entered with Mr. John. What are the remedies available for Mr. John? What are the remedies he can get from court? One of such remedies is damages. That damages is simply monetary compensation for the loss he has suffered. And damages can be general, it can be specific damages. It's left for your lawyers and the court. Your lawyer will know how he will plead in court for you to request specific damages, and he knows when to request for general damages. Then we have specific performance. When we talk of specific performance, it's just you asking the court to order the other party to carry out his obligation. You are telling the court that it should order the other party to carry out your own obligation, and the other party is yet to carry out his obligation. For instance, is a supply of 50 bags of granules by Mr. John to Mr. Johnson. Yes, Mr. Johnson has supplied the 50 bags of granule. You, Mr. Johnson, pay him his 50,000. That is specific performance. You are telling the court to order it. Then we have ratification. Ratification is just court altering the terms of the contract, which court rarely does. But if it will serve justice, the court will do it. For instance, Mr. Johnson supplied 50 bags of granule and he ends up supplying 20 bags. The court can say, okay, you, Mr. Johnson, just pay Mr. John for that 20 bags. Take the 20 bags and you go and part ways. You guys part ways. The contract discharge. So it's one of the remedies. You can approach, Mr. John can approach the court that, okay, since I've supplied him for 20 bags instead of 50 bags, he should pay me for my 20 bags. The court will order Mr. Johnson to pay him. They will rectify the contract. And we have what we call injunction. Injunction is just restraining a party from doing something. Let's say in trespass or in case of encroachment into land and the rest. These are remedies available. And depending on the circumstances of the case, injunction can also be mandatory. That is, you asking a party to do something, just like specific. Sometimes lawyers know how to apply such. Then we have what we call quantum merit. When we talk of quantum merit, we are just saying you should be paid according to the service you've offered. The reasonable service you offered so far, you should be paid in accordance to such. Let's say you are building duplex for a client, you've reached to a certain level, then suddenly the client said he doesn't want your services anymore. So you can approach the court and say, okay, he should pay you for the services you've offered to him so far. So that's quantum merit. Then we have rescission. Rescission in the sense that the court will rescind the contract totally because the other party is in breach. Maybe it's to supply you something and he has failed to supply it, and the time which he is meant to supply it, he has failed to supply it. You can approach the court and say you should rescind that contract. So thank you very much for your patience, for staying, for those that stayed back while we were experiencing a serious network problem. I want to once more apologize for that. It wasn't our intention, but we've come to the end of today's class. So if you have any question, the only person remaining, if you have any question, you can ask, you can unmute your mic. If there's anything you did not understand in the course of the lecture, unmute your mic and ask your question so that I can answer, or you have any observation or anything. And we apologize for the challenges we experienced earlier, which has made the class to last this longer. So if you have any question, contribution, now is the time. Now is the time to do so. Unmute your mic, ask your question if you want to. Mr. David, do you have any question? Because your mic is on mute. You have a question?
Sir, I don't know, sir. Well understood.
Okay, we've come to the end of this class.
No, I don't.
So this is, you only have one module today, and this is the last module. Tomorrow will be graduation. So tomorrow you will be giving the graduation speech. Just keep tabs on the platform, on the WhatsApp platform tomorrow. The program manager will drop a message for you on the graduation, and your certificate will be distributed after the graduation to you guys. So thank you very much, and thank you for patronizing us at your school for the purpose of obtaining the loan. So we've come, and there will be post quiz after I've left. So you can just log into the platform, and you can just go to the platform, and just do your piece and post your score too on the platform. Thank you very much. Thank you and goodbye.